You come home tonight. The locks are changed. Your stuff is on the curb. Your landlord says you're out. But here's what they don't want you to know. What they just did? It's illegal, and you can fight back. Here's what you'll know by the end of this video. What makes an eviction illegal? The 5 defenses that actually win in court, and the exact words to say to protect yourself. This is your legal edge. Most landlords count on you not knowing this. Let's fix that right now. An eviction is only legal if it goes through the court. That's it. No exceptions. Your landlord cannot just tell you to leave. They cannot change your locks. They cannot shut off your water or power. They cannot remove your belongings. They cannot threaten you into leaving. If they do any of this without a court order, it's called a self-help eviction, and it's illegal in nearly every state. That means you can sue them, you can get back in your home, and in many states, they have to pay you damages. Now, let's talk about the 5 defenses that actually win eviction cases. Defense number 1, improper notice. Your landlord must give you written notice. The exact number of days depends on your state. 3 days, 30 days, sometimes 60. If they got the time wrong or didn't put it in writing, the case gets thrown out. Defense number 2, retaliation. Did you complain about repairs? Did you call the health department? Did you join a tenant union? If your landlord tried to evict you after that, it might be illegal retaliation. In many states, there's a presumption of retaliation, often 6 months, sometimes up to a year. Defense number 3, habitability. Your landlord must keep your place livable. That means working heat, running water, no mold, no roaches. If they didn't fix serious problems, you may have a defense. In many states, you may have a defense if you withheld rent on a place that's not fit to live in. But the rules vary, so check your state's law. Defense number 4, discrimination. Under the Federal Fair Housing Act, Title 42, Section 3604, it's illegal to evict someone because of race, color, religion, sex, national origin, disability, or family status. If you have proof they treated you different, that's a federal fair housing violation. Defense number 5, they didn't follow the process. Eviction has strict rules. The landlord must file in court. You must be properly served. You must get a hearing date. If they skip any step, the eviction is invalid. Now here's what to do when you get that notice. Don't panic. Don't move out. Read the notice carefully. Write down the date you received it. You have a deadline to respond. It could be 5, 7, or even 21 days depending on your state. File your answer with the court before that deadline. In your answer, list every defense that applies to you. Improper notice, retaliation, bad conditions, whatever fits your situation. When you go to court, bring everything. Photos of the problems, texts from your landlord, emails, receipts for repairs you paid for, copies of complaints you filed. The more proof you have, the stronger your case. And when you speak to the judge, stay calm, be respectful, stick to the facts. You say this: Your Honor, I am contesting this eviction because my landlord did not follow the legal process. Then explain your defense clearly. Judges see landlords cut corners every day. If you show up prepared, you have a real chance. One more thing. If your landlord already locked you out illegally, call the police. File a report. Then go to court and file for emergency relief. You can get back in. You can get damages. And in some states, you may be able to make them pay your legal fees. Most tenants lose because they don't show up. They don't file an answer. They don't know they have rights. But you're different now. You know the law, and the law is on your side. This is not legal advice, but it is legal knowledge, and knowledge is power. Subscribe, because knowing your rights starts here.